Welcome to TMZ Live, Harvey Levin here, and we got a big update in the ongoing Diddy case. Things are finally winding down, and we're about to enter the final stretch. Closing arguments are set for this Thursday and Friday, and by early next week, the jury will begin deliberating on what could be one of the most high-profile and complicated celebrity criminal cases in recent memory. So here's where we stand. Just today, the prosecution filed paperwork with the judge. Actually, it came in the form of a letter requesting revision to the jury instructions. The goal? To simplify things. The case itself includes numerous serious allegations: kidnapping, arson, aiding and abetting sex trafficking, among others. The prosecution wants to streamline these charges in a way that avoids overwhelming the jury with legal terminology, technicalities, and redundancy. It's a smart move, especially when dealing with a RICO charge, which already involves a lengthy list of underlying criminal acts. More specifically, the prosecution is asking the judge to remove references to attempted crimes, such as attempted kidnapping and attempted arson, from the jury instructions. They're not dropping those charges. Rather, they're arguing that they present the case as actual crimes having occurred, not merely attempted. Including both attempted and actual versions of the charges, they say, is unnecessary and potentially confusing for the jury. As they put it, if you believe the crime actually happened, why confuse the issue by discussing a failed or incomplete version of that same crime? This makes sense legally and strategically. When jurors are handed complex instructions, especially in a case like this with 4 counts, including the overarching RICO charge that acts like a net catching multiple alleged offenses, things can quickly get muddy. The prosecution is trying to ensure clarity. They want jurors to focus on the substance of the charges and the core evidence presented, rather than getting lost in parsing through duplicative or legally redundant language. And here's another key point. Both sides, prosecution and defense, are expected to use 1 full day each for their closing arguments. That means Thursday is prosecution day, and Friday is the defense's turn. Once both sides have delivered their final pitches, the judge will instruct the jury, a process that could take several hours, especially given the case's complexity. Because of that, it's highly unlikely the jury will begin serious deliberation until Monday. While they might technically be able to start late Friday afternoon, the reality is that deliberations won't begin in earnest until a new week. So let's talk about what happens then. This is where it gets interesting and a little bit complicated. The trial has lasted 28 days. That's nearly a month of testimony, with 34 witnesses brought to stand. That's a mountain of information for the jury to sift through. Some jurors might come into deliberations with strong opinions, while others might still be undecided. People outside the courtroom, watching the coverage, seem split. Some say Diddy's guilty across the board. Others believe he'll walk. Some think the RICO charge is a stretch, while others believe the aiding and abetting charge is where the real action is. The consensus among legal experts, and, frankly, common sense, says the jury is unlikely to be unanimous right out of the gate. These kinds of high-stakes cases often spark intense debate, especially given the number of charges and the complexity of the evidence. Even a split like 11-1 or 10-2 can lead to long, drawn-out discussions. Now, here's the pressure point: the calendar. Next week includes the 4th of July holiday. The court is officially closed on Thursday, July 3rd, and Friday, July 4th. That means that the jury hasn't reached a verdict by the end of Wednesday. They face an uncomfortable choice: either come back to court after the holiday or risk being dragged into deliberate during what is supposed to be a break. This is where things often get interesting, because jurors are human. They have lives. They've already sacrificed a significant part of their summer to sit through this trial. They've endured sweltering New York heat, long days in the courtroom, and likely missed out on a number of family events or vacations. Add to that the fact that most people want to enjoy Independence Day with their families and friends, watch fireworks, go to cookouts, and just relax. The idea of potentially being sequestered or called in with only a skeletal court staff on a national holiday might be enough to push some fence-sitters toward a consensus. It's not unheard of. In fact, history shows that when a holiday looms, juries are more likely to reach a decision faster. Maybe it's coincidence, maybe it's psychological, but there's something about the pressure of a long weekend that motivates people to come together. Some might suddenly find clarity in evidence that seemed murky before. Others might decide it's just not worth the argument. And in a split situation, say 10 jurors are ready to convict and 2 are holding out, there's going to be a lot of social pressure to reach agreement, especially when people's summer plans hang in the balance. Of course, there's always the hope that the jurors take their job seriously, and they should. We expect them to evaluate the facts and evidence with integrity, not based on holiday schedules. And to be fair, many do. But let's not pretend outside factors like time, fatigue, and personal lives don't weigh in. This jury already gave up Memorial Day weekend. They've been trudging in and out of court during one of the hottest New York Junes on record. They've sat through a case full of disturbing and complicated allegations. Also worth noting, Judge Subramanian is not the kind of judge who's going to allow a mistrial just because the jury can't agree after a few days. If, by Wednesday, they say they're deadlocked, she's likely to reject that and instruct them to continue deliberating. She could even call them in during the holiday weekend with minimal court staff, just enough to allow the jury to continue their work. That's pressure no one wants. From a legal standpoint, this strategy of streamlining the instructions and forcing deliberations up against a tight deadline is smart. It helps clarify the prosecution's case and subtly places additional urgency on the jury to work things out. It's a subtle form of legal leverage without directly influencing the jury's independence. But again, none of this guarantees a fast decision. This could easily spill into the following week, especially if jurors remain divided. Still, the pressure cooker environment created by the upcoming court closure and summer holiday could push things to a resolution quicker than expected.